Here's the latest in 2A news. Trump's big beautiful bill is now in the hands of the Senate, and I have some exciting news I thought we'd kick this week off with. On a recent episode, I told you that certain provisions of the HPA were inserted into the bill before it was shipped to the Senate. That in and of itself is really positive. Well, it seems like Republicans are continuing to add pro-Second Amendment language into the bill. The latest addition is more amendments to the NFA. That's right. The updated bill language now only defines a firearm under the NFA to include a machine gun or destructive device. That means SBRs, SBSs, silencers, and AOWs would be removed from the NFA's control. It additionally would strip the ATF's ability to regulate shotguns, inasmuch as it alters the definition of destructive device to remove the sporting purposes clause, which the government has used to block the importation of certain shotguns due to cosmetic features. Think tactical shotguns. The taxes on AOW transfers would be eliminated, and so would the taxes on SBRs, SBSs, and silencers. On top of that, if a state has a law that permits the possession of SBRs, SBSs, or AOWs because the person has acquired one with conformance with the NFA, the new proposed language would ensure possession is lawful in those states by stating that compliance with the GCA shall be treated as meeting any such registration or licensing provision. Sounds pretty good, right? Well, almost. That last provision I mentioned about meeting the requirements of registration doesn't mention silencers. So, if they're not added in, states could still potentially create issues for their residents. If this passes, there may not be federal restrictions, but without silencers being added, states could restrict their possession. Additionally, there's a 90-day delay between the passage and implementation, which means there's going to be a lot of stuff sitting in limbo while everyone waits to buy if this thing actually passes, and the gun industry will suffer during that time. Suffice to say, I'm a bit surprised that all this language has been added, and I really hope that this will pass. So I'm going to bang that drum one more time. You guys know what you need to do. Make your voices heard by picking up the phone and calling your senators. Welcome back to the Big 2A, the show where we bring you all the top Second Amendment stories. I'm your host, Adam Kraut, and GunCon is next weekend, so I hope I'll see you there. I'm going to be on the Second Amendment panel with my friends from the NRA, FRAC, and GOA. So if you haven't gotten your ticket, head on over to guncon.net and do that now. Use code TGC to save a couple bucks. Last week, the federal government filed an amicus brief, that's friend of the court brief, in the many challenges of which there are 4, to Illinois' assault weapons ban and magazine capacity restrictions, which were all consolidated or put together in one case. Once again, we see the Trump administration taking a strong stance on gun rights. Raise your hand in the comments if you thought the Trump administration would be doing just this. I didn't. The brief opens with a statement that the case poses important questions about the scope of the Second Amendment's protections and that the United States has a strong interest in ensuring that these important questions are correctly resolved. That being, the Second Amendment is not treated as a second-class right, and that law-abiding Americans in this circuit, the Seventh Circuit, are not deprived of the full opportunity to enjoy the exercise of their Second Amendment rights. The DOJ also points out 3 reasons the Seventh Circuit should affirm the lower court's injunction. First, several aspects of an earlier decision by the Seventh Circuit were wrong. Second, multiple Supreme Court justices have made it clear they disagree with that earlier case and other recent lower court opinions. On top of that, SCOTUS is likely to grant cert on this issue in the next term or 2. They're referencing that dissent we talked about last episode. And finally, after the Seventh Circuit decided that earlier case, the lower court held a multi-day bench trial which resulted in factual findings that the Illinois law violates the Second Amendment. I'll say that again for those in the back. The Illinois law violates the Second Amendment. One of the interesting things is that the DOJ states the AR-15 is in common use by law-abiding citizens for lawful purposes, including self-defense, target shooting, and public defense. Now that's an argument you don't get to see many lawyers making, and it goes beyond mere self-defense. Yeah, apparently the DOJ is for the militia now. The brief embraces the common use test, which the Seventh Circuit previously transformed into the commonly used for self-defense test, something that flies in the face of Supreme Court precedent. Right after we filmed the last episode, the Supreme Court released its unanimous opinion in Smith & Wesson v. Mexico, which had a line stating, "The AR-15 is the most popular rifle in the country." Point being, if the Seventh Circuit properly applied the test, AR-15s would clearly be protected, as the government rightly points out. The DOJ also argues that the state may not ban a class of weapons on the grounds that they are militaristic arms. In its argument, the brief nods to the idea that people may acquire arms for the common defense, in addition to the individual right to self-defense. Again, that's a big deal. I think you guys are going to love this part. In the section arguing that so-called large-capacity magazines are protected, the DOJ states that the Second Amendment protects firearm attachments that are useful to the exercise of the right, including magazines, suppressors, and other firearm attachments that are in common use by law-abiding citizens for lawful reasons. Who would have thought you'd see the federal government arguing that silencers are protected under the Second Amendment? I know I didn't. All in all, a solid brief in support of Second Amendment rights by DOJ. We've seen the DOJ weigh in on this. Do you think we're going to see some states coming out in support of the Second Amendment with briefs along these lines? That would be very interesting. Let me know your thoughts down in the comments. Now, for some more different 2A news. John made me say that.
I did.
On Tuesday, the clerk's office of the Fifth Circuit Court of Appeals issued a notice to the lawyers in the United States v. Peterson case that, pursuant to the court's directive, it was withdrawing its opinion. Now, I know what you're thinking. But Adam. But Adam. WTF is this case about, and is this a good thing? Here's the short version. George Peterson was the proprietor of a firearm business that he operated in part out of his home. In the summer of 2022, a search warrant was executed at his home as part of an ongoing ATF investigation. Among the items discovered was an unregistered silencer. I bet you can guess what happens next. Peterson was indicted for the possession of the unregistered silencer. He then filed a motion to dismiss on the grounds that the NFA's registration framework violated the Second Amendment and that the search by ATF violated the Fourth Amendment, so the evidence obtained should be suppressed. In a recent ruling, the Fifth Circuit held that silencers were not arms protected by the Second Amendment. That ruling is the one we're talking about here. So, what does this mean? Well, Peterson has sought en banc rehearing, or to have the Fifth Circuit as a whole rehear the case. In the interim, the government agreed that silencers are protected arms, but argued that regulating them under the NFA is consistent with the nation's history of firearms regulation and therefore constitutional. Additionally, the government has said that rather than taking the case en banc, the panel should just correct the plain and text analysis and rule for the government based on its historical arguments. Right now, all we know is that the Fifth Circuit has withdrawn its opinion. That could mean that the panel itself will issue a new opinion or that en banc review will be granted. However, given the government asked for the opinion to be altered, the first option is probably the more likely scenario. What would they say? Well, I don't know, but it could be something of a split in the sense that the panel could say that they're protected arms, but the regulation of them is consistent with the nation's history of firearms regulation. It could also say they are protected arms and that the regulation is inconsistent with the nation's history and tradition of firearms regulation. So if that happens, perhaps it will further start to unravel parts of the NFA. We're going to find out together. Now, for some unsurprising 2A news, 16 states are suing the parties to the FRT lawsuit, seeking to block the return of the forced reset triggers to their owners following the settlement of the litigation between the FRT people and the federal government. And if you missed that news, we covered it on a previous episode. Led by New Jersey, the new lawsuit begins with a declaration that gun violence is a national scourge. I would argue that politicians are a scourge, but that's one for another episode. It goes on to recount the settlement agreement and take issue with the fact that the federal government has agreed to return FRTs to not just the parties, but anyone, anywhere. The states claim that this decision will only endanger the public and is contrary to federal law. After spending several paragraphs describing the harm they claim guns cause in their communities, the states then turn to the NFA and the regulation of machine guns. And here's where they try to link it all together. In the following section, the states discuss machine gun conversion devices a la Glock switch. And they essentially argue that FRTs are just that, a machine gun conversion device. The complaint brings two causes of action. First one being that the federal government is acting beyond their legal authority, essentially saying that FRTs are machine guns, and because they're machine guns and Section 922.0 exists, the ATF is acting beyond their legal authority in returning machine guns to people. The second one is a claim under the Administrative Procedures Act, which is interesting because the lawsuit's challenging a settlement agreement, not some kind of rulemaking. In any event, the states claim that the redistribution policy, which stems from the settlement agreement, is a final agency action subject to the APA. We'll see how that one works out for them. If you had your FRT stolen by the government, let us know in the comments if you got it back or it's still sitting in limbo. Next up, some good news out of the Supreme Court. Right after we filmed the last episode, like I mentioned earlier, the court released its opinion in Smith & Wesson v. Mexico. In a unanimous decision, including the liberal justices, since, that's what unanimous means, the court held that Mexico's $10 billion liability suit was barred from moving forward by the Protection of Lawful Commerce in Arms Act. This is the first time the Supreme Court has ruled on PLACA, and it's a big win for the Second Amendment. Now, I know what some of you are probably thinking. This was a lawsuit against the industry. How is this a big win for the Second Amendment? Well, let me tell you. If lawsuits like the one Mexico brought were allowed to continue moving forward, it would bankrupt the industry, which last I checked was where most people acquired their arms in order to exercise their Second Amendment rights. No industry equals way fewer guns. Here's the quick version of what happened. Mexico advanced three theories. First, the manufacturers supply firearms to retail dealers whom they know illegally sell to Mexican gun traffickers. Second, Mexico claims that the manufacturers have failed to impose the kind of controls on their distribution networks that would have prevented those illegal sales. And third, the manufacturers make design and marketing decisions intended to stimulate cartel members' demands for their products. With guns like this. We all know how the supply chain actually works. That being, the manufacturer sells to the wholesaler, who sells to the dealer, that sells to the end customer. While Mexico alleged there were a few bad apples, and more importantly that the manufacturers knew who those bad apple dealers were, the court didn't buy that. It said, in asserting that manufacturers intentionally supply guns to bad apple dealers, Mexico never confronts that the manufacturers do not directly supply any dealers, bad apple or otherwise. They instead sell firearms to middlemen distributors whom Mexico has never claimed lacked independence. As to the second theory, the court said that a manufacturer of goods is not an accomplice to every unaffiliated retailer whom it fails to make follow the law. And more importantly, such omissions as it relates to implementing controls over the dealers and inactions, especially in an already highly regulated industry, are rarely the stuff of aiding and abetting liability. In other words, the court didn't buy it. On the last theory surrounding the design and marketing decisions, the court noted those products are both widely legal and bought by many ordinary consumers. The court also stated the manufacturers cannot be charged with assisting in criminal acts just because Mexican cartel members like those guns too. The same is true of firearms with Spanish language names or graphics alluding to Mexican history, like this one. The court concluded, recall that Congress enacted the statute to halt a flurry of lawsuits attempting to make gun manufacturers pay for the downstream harms resulting from the misuse of their products. In a findings and purposes section, Congress explained that PLACA was meant to stop those suits, that being to prevent manufacturers and sellers from being held liable for the harm caused by those who criminally or unlawfully misuse firearms. Mexico's suit closely resembles the ones Congress had in mind. It seeks to recover from American firearms manufacturers for the downstream damage Mexican cartel members wreak with their guns. The fact that the Supreme Court gave a unanimous decision in favor of PLACA could mean we see fewer types of these cases in the future, or, at the very least, district courts doing the right thing and throwing them out right away. And that's good news for gun rights.